Alex here with part 65 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. This video leads into my ex's motion to review and modify child support. This is one of the few motions she files throughout the case, and I do remember a little bit about the ordeal surrounding the modification of child support. They had, I believe at this point recently, or she had recently had her child support raised to $300 and something. And after some time, after Circuit City, was bankrupt, and I ended up finding a new job. Actually, I think I found a new job at Staples, and she didn't try to modify child support at that point. And then after that, I found another job at a company called Summit Collection Services, which is a collection agency. And at that point, she did try to modify child support. I can't recall the details, but I do remember her attorney talking to me about it prior to filing the motion, or at least I have this vague recollection of it. And what I remember is that we had a dispute as far as the computation on the bonuses that I was receiving at the time, because they were, I think we could probably talk a lot more about them when we get to the order. So let's go ahead and hold off on that. We'll eventually get to an order at this point, but I do remember that we didn't come to an agreement as to how to compute the bonuses, how to factor that into the child support formula. And so she does file this motion to have child support reviewed. I don't oppose the review. I know that it'll eventually lead to the actual analysis by the court as to what the child support should change to. And the dispute is not that the child support shouldn't change. It's just that the child support shouldn't change as far as, or to the specific amount that my ex's attorney wanted it to change to. So again, we'll be able to talk about this a lot more when we actually get to the court's order on it. But for now, let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's motion for the review and modification of child support. As with the previous filings, in the first paragraph she identifies my ex, she identifies herself as the attorney that is representing my ex, and she identifies this particular document as a request to review her current child support obligation. Points and authorities, looks like she's not going to go with a factual background this time. Usually that's done because the document is very short, and just by glancing at this, it looks like it is going to be a pretty short motion, so that makes sense. Initially, she raises the assertion that the court has the authority to consider the motion, although a portion of this case is on appeal. This is true. I don't know why she cites Lewis v. Lewis, though. I feel like what she should have cited is McManley v. Manley. But in any event, yeah, I think I'm probably right about this, because if you look here, you can see Lewis v. Lewis is a 1955 case. I might be wrong, but I do believe Rust is the case that talks about the Rust talks about how the court is divested of jurisdiction on appeal, and I believe McManley v. Manley talks about the fact that the court can rule on issues that are not on appeal. I might check it out after the video. I'm not going to bother to do it right now because it's not important. Even though it's a newer case, it says pretty much the same thing that she's trying to say with the Lewis citation anyway. It's just a newer case. And yes, this is something that the court can do. I have a video on this topic, and the video is called Jurisdiction Divested on Appeal. And in the video, I do explain what this attorney here is saying, which is that even though the court is divested of jurisdiction on appeal, it is not divested of jurisdiction over everything. It is only divested of jurisdiction on the particular issues that are actually on appeal. So child support not being on appeal means that the court still has jurisdiction over child support issues. Next assertion here. There's been a substantial change of circumstances since the last child support order. I don't know why she's using, I guess, it's weird to use that. The change of circumstances doctrine is used to modify custody. There's a statute that talks about how to modify child support, and I don't think they use this language. Maybe they do, but I don't think they do. Let's go ahead and read on. Stipulation was submitted to the court. A stipulation is an agreement between myself and my ex, and in that agreement, my ex agreed to pay a certain amount of child support based on the Wright v. Osborne formula. I've talked about this formula in the video, child support, so I won't talk about it again now. Next assertion is that my child support, or my ex's, wait, she's confusing me here. Okay, so even though she's saying I have a child support obligation, what she really means is that under the Wright v. Osborne formula, the amount that I would have had to pay had I not had physical custody would have been $206.95. Looking at this paragraph, it makes it look like I'm actually paying child support, but I'm not. And it actually kind of reconciles itself in the next paragraph, because she does mention my ex also has a child support obligation of $612. So we obviously can't both have a child support obligation. What she's doing is she's going through the Wright v. Osborne formula, which is to pick up or to put together the two different income amounts between myself and my ex, and I believe she's going to go into the offset next. Yes, she does. So the next assertion is that the formula, when calculated, leads to a requirement for my ex to pay me $330, which is correct. The court affirmed the stipulation. I don't know why she approved the stipulation on July 26, 2010. Next assertion, since that time, I have obtained full employment with Summit Collections. That's true. When I was working at Staples, I wasn't working 40 hours a week. Anyway, I've obtained full employment with Summit Collections, and it's believed that I am earning substantially more than I was earning when the stipulation and order was filed. She also believes that I have received a bonus at Christmas, a Christmas bonus. Okay, so that was just coincidental that it was during December. It wasn't actually a Christmas bonus. It was basically commissions. In collections, you get paid based on your commissions. And it was a lot. But again, I'd like to take the opportunity to bring all of that up when we get the order. I don't want to talk about it too early, because I'm eventually going to get to that point anyway. Next statute here is that the court is allowed to review child support at any time on a basis of changed circumstances. Okay, so that's where she got that logic, or that phrase from. So this statute specifically mentions changed circumstances. Then they define it in that same statute. Now this makes a lot more sense now, because the change of circumstances that I was thinking about is defined in a different statute, and it discusses modification of child custody. So it looks like change of circumstances has another definition under the modification of child support statutes, and that's just one of those things that brings up why context matters in law. You know, change of circumstances means one thing under this statutory scheme and something completely different under this other statutory scheme. It's just how it works. So yes, the change of 20% or more mandates a review of modification, which is true. So if in Nevada, at least when this law was in effect, which I do believe it still is, in Nevada, if you had a change of circumstances, the court had the discretion to entertain a review. But if you had a change of 20% or more, the court no longer has the discretion. Now the court must review and modify child support. The other occasion when the court must review child support is when 3 years have passed. So there's a few ways to do it. 3 years have passed, or 20% or more in gross monthly income has changed, or, the other way is the court doesn't have to do it, but they could just decide, you know, even though neither of these two things apply, we have the discretion to entertain a review, and we're going to go ahead and do that. Most lawyers don't bother taking that risk. They just wait until one of the two major events comes up, the 3-year event or the 20% event, because if you wait until that event, you're going to get a review. The law requires a review. It's less risky. You know you're going to get what you want. You don't know what the amount is going to come to, but you do know you are going to get a review. Next assertion is that I'm earning $228 a month more than I was at the time of the stipulation order. Then the review is mandatory, so which is exactly correct. This lawyer is correct about this. Next assertion here is, since I am employed for at least 4 to 6 months, that it's important that the court consider ordering not only the last 3 months of pay stubs, but also pay stubs for the last year. I don't know why that's relevant, because if it's done over the last 3 months, then you just divide it over 3 months. So she's making it seem like something bad will happen if the court takes a longer snapshot of time. This will come up later in this series, so I'm going to hold off on it for now. Affirmation, which is the sentence that must be included in these documents to indicate that you reviewed it and made sure there's no social security number. Muriel Skelly. Oh. See, I always wondered if this person worked for her, and I haven't seen her signature on any of these papers the whole time. This is the first time I've seen this signature, so that's interesting. Declaration. My ex's declaration is required, just like mine is required. Anytime a motion is filed, you have to swear under penalty of perjury that what you are asserting is true and correct. That's what that is. Certificate of mailing, which is just indicating to the court that this document was mailed to me under Rule 5. And the motion opposition notice, which is a standard form we've gone over probably 100 times by now. And this is a form that you just go through the instructions, check the boxes, and at the very end you determine whether or not you have to pay a filing fee. In this particular situation, my ex did not have to pay a filing fee. Very short document, a lot quicker than I thought it would be. Going into the aftermath, I didn't file any documents, so I incurred $0 in costs. My ex did file a document, but based on the motion opposition notice, it was a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent an hour on this. I'm not saying the entire document would have taken an hour. I do think there would have been some back and forth over the phone. She would have had to verify that I actually had a job. I do recall her talking to me a little bit about this, so factoring in the communication to my ex, the communication to me, and the preparation of the document, I do think 1 hour is a conservative but reasonable estimate of what she probably put into this. So at the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.